Welcome everyone to day 2 of the ID Law 2021 conference. Thank you all for joining us for another day of exciting conversations and presentations. I will now hand over to Žiga to take us into the first session of the day.
Hi, thank you, Tima. Thank you for the mic. Before we start with the customary technical questions, if everything is working, I would just like to briefly introduce you to the session 4, that is the first session of today. This session is called Due Diligence Obligations for a Transparent and Safe Online Environment 2. And this session 4 will build on yesterday's session 3, which covered, among other things, obligations applicable to all providers of intermediary services. For example, the obligation to designate a legal representative in the EU, and the topics covered with regard to additional obligations applicable to providers of hosting services, in particular to put in place mechanisms to allow third parties to notify the presence of alleged illegal content on the platform. This is what has been covered yesterday, and today we will focus our discussion in this session on the obligations of large and very large online platforms as laid down in sections 3 to 5 of chapter 3 of the DSA. As customary at this event, we will begin the session with 2 lectures held by Werner Stengg and Gerald Spindler. Afterwards, Aneta Wiewiórowska-Domagalska will comment on these lectures. Let me briefly introduce our first speaker, Werner Stengg. He's a member of Executive Vice President Margrethe Vestager's cabinet. Prior to this, he was head of unit in Directorate General Internal Market Services and was responsible for better regulation cycle for online and postal services and for public interest services. Then I may ask you to come to the digital floor. Thank you.
Yes, hello. I hope you can hear me. I still have difficulty starting the video because it says the host has stopped it.
Should work now.
I think it will in a second. Now, here I am. Yeah, hello, good afternoon, everybody. Many thanks for inviting me to speak on the DSA. I think I have 15 to 20 minutes to focus on section 3, the rules applicable to all online platforms, before Mr. Spindler will continue with the large gatekeeper platform provisions. Probably just a word of introduction before going directly into section 3. I know you have been discussing this now for a full day, but still from my perspective, European Commission perspective, just to recall still what the overarching objectives are in which all of these provisions have to be seen, and also to explain a bit more sort of the balances that needed to be struck between sometimes contradictory objectives. So the one and first objective certainly was to create a safe online environment, to make sure that users of the internet are not unduly exposed to illegal material of any kind, from illegal products to hate speech to terrorism to child sexual abuse material, what have you. At the same time, and equally so, we hope to ensure that legal content stays online, or at least it can be challenged if content has been taken down, which leads to the second objective, which is about democracy. With this whole instrument and also the DMA, we've been trying to make sure that there is stricter democratic oversight over decisions taken by platforms, in particular large platforms, that sort of concern all of us, whether we are able to sell products, share information, see information. So greater transparency, greater accountability. We also want the single market. So there's also a pro-innovation objective in this, because the single market has traditionally been our greatest asset in Europe. And because of all those risks that we are trying to address in the DSA, we have also seen a proliferation of national measures trying to address some of those downsides. But we need the single market. We need a single market for our companies, also digital companies that want to scale up in Europe, but also for the many users of those platforms. Because even if we now focus, of course, all the time on the problems and how we try to solve problems. You should not forget that millions of small businesses depend on platforms to offer their products and services. And we as consumers, of course, also benefit from wide access to information and products. Now, you've also seen in the previous sessions that we have chosen a risk-based approach. And coming forward with our due diligence obligations, we try to make sure that we distinguish between different types of business models depending on the risk that come with those, which is why in the first section you really had some basic requirements when it comes to intermediation services to do not host user-generated content. And in the last session, you then saw those where users may upload content but not necessarily shared with the rest of the world, which is why we already had the notice and action procedures and the information to those whose content was removed. Now, in this section, we are moving on to the next category, online platforms, which are being understood as those typical multi-sided markets where someone uploads content either to sell it or to share it for other reasons, which can potentially be seen by all of us. So whether you go on booking.com or on YouTube or on Facebook or on the App Store or on any other type of online platform, if ever something illegal is happening there, that of course has much further reaching repercussions, both to those that may be exposed to that content, but also for legitimate businesses, for instance, that compete with illegal content. So there's also a certain level playing field argument in all of this. If I'm a legitimate trader in Austria, whether online or offline, I sell stuff to consumers, I comply with all rules that are in place, and I'm competing with imports, for instance, from China that may not meet our product standards. So it's not just, which is important enough, not just to protect the consumer on the receiving end, but it's also to ensure a level playing field between those that respect our laws and those who don't. Now, in this section, we are building on the previous one because we had said you need a notice and action system and you need to give a statement of reasons. Now, we are adding a couple of things. The first is ways to challenge those decisions, because since the impact is much bigger, if, for instance, you have removed my content from your platform, all of a sudden I'm no longer seen, but my business or even my private initiatives may have been perfectly legitimate. Now here we introduce some mechanisms to challenge those decisions. That's the internal complaint handling system in Article 17, but also then the out-of-court dispute settlement, where, by the way, we copied provisions from another piece of law that was enacted in the last mandate, which was the business-to-platform regulation, where we gave precisely those rights already to business users of platforms. But now we are extending this to anybody whose content on any online platform has been removed. So that's a very important feature. It's this counter notice feature, if you want. It does not delay the removal of illegal content. So the platform does not have to wait for this complaint handling system, discuss with me for 3 weeks. And in the meantime, illegal content unfolds its negative, its adverse effects. But if I'm being heard and if I was right, then my content will be reinstated. The next chapter, also very important, the trusted flaggers. Here it's about who is actually providing notices to the platform. Of course, everybody can do this, and this was the purpose of the notice and action provisions in the previous section. So I, as a citizen, can go up and inform YouTube that I think there was child pornography or child sexual abuse material on that platform. But the trusted flagger idea comes from the experience that there are organizations or bodies that have more experience, more competence in making this judgment call. Can be very different types of organizations, if you want. We have this on child sexual abuse material, for instance, with the InHope network. These are people specialized and also authorized, actually, to look at such material. And if they send a notice to a platform, that usually is indeed, the material is indeed illegal. Europol does the same thing with terrorist material, sending it to the platforms. And there are many other instances. Even in more difficult areas like hate speech, we have a code of conduct going on where it's also being measured to what extent the so-called trusted flaggers there are more reliable in making allegations of illegal content than just any individual one. And again, here the finding was that the false positives are much more limited. Hence, a preferential treatment, if you want, of trusted flaggers. If they notify a platform, the content will be removed with priority and without delay. But of course, the article also contains safeguards in having criteria on what do you have to do to qualify as a trusted flagger. But also, very importantly, once you've got that status from the digital service coordinator, you must keep earning that status. It's not once you are a trusted flagger, you are this until the end of your days. But if your notices turn out to be much less reliable than you claim them to be, that status can and will be revoked as well. But that was one of the instruments where we tried to bring in more players, if you want, into this game, because in the past it was only the platform on its own discretion deciding whether or not to act and how, without any transparency. Now we are bringing in first this counter notice possibility for those concerned. We're bringing in the trusted flaggers. We're also bringing in, comes a bit later, independent researchers that would get access to data to see what is happening on those platforms. The next article is about, it's called Measures and Protection Against Misuse. We also sometimes colloquially refer to it as repeat infringer policies, which means that two situations could happen. The first is one and the same person or company keeps uploading illegal content, comes back again and again with the same content or with other illegal content. Or the other situation being that someone notoriously sends wrong notices again and again, because we also know a phenomena of this being used for anti-competitive practices, that you're trying to bring down the services of your competitor. So if the platform identifies such repeat infringing behavior, they then also have to act against this. The typical example is a trader selling through a platform from China into Europe, and market surveillance authorities find out the trader under different names perhaps comes back again and again. Then we're not just chasing each piece of content that has been notified, but we try to make sure that at the source, that trader is being suspended from the provision of their services. We then come on to Article 21, which is notification of suspicions of criminal offenses. This is now, again, relationship between the platform and law enforcement, trying also to make sure that where a platform becomes aware of serious criminal offenses, that they are obliged to inform law enforcement of this, so that law enforcement can also take action against those behind the illegal activities, if you want. Turning the page, literally, we come to a very, very important provision, which is the traceability of traders, also known as the Know Your Business customer obligations. This is one example where, for instance, we have differentiated between different types of services, because here it is really where someone is on a marketplace, is selling stuff to consumers. So that's very much a consumer protection measure. It is not applicable, for instance, on a social media platform, that they have to identify my identity if, as Werner Stengg, I post something on Facebook. There we did not want any traceability obligations for obvious reasons, that we didn't want to stifle freedom of expression. But here we are talking about traders coming and selling stuff, and that stuff needs to comply with our laws, obviously, consumer protection, safety, what have you. And they need to be properly authenticated, identified before they offer their services on this platform. And you see a number of information items that they have to provide. And part of that is also then shown to the consumer that actually goes to the platform, finds a trader selling on that platform, and obtains much more detailed information about the identity of that trader. So again, strong consumer protection dimension. Let's move on, looking at the watch. At the end, you have the transparency reporting obligations. You will see that each section has additional transparency reporting obligations, again, in the spirit of risk-based provisions. Here it is very important, since you're talking about content moderation, about the removal of content, that there is clear reporting on what is happening on that platform. What the takedowns were already reported in the previous section, but here also a number of disputes in out of court settlement, number of suspensions against repeat infringers, but also very importantly, on any use they make of automatic means of content moderation, which on the one hand is also encouraged through the Good Samaritan clause that you discussed in another section. But it's more generally important because this is, of course, often criticized. An algorithm, a machine has taken down my content, so we need clear transparency around the use of automated means of content moderation for the sake of transparency and accountability. In Article 24, which is actually the last article in this section, we turn to online advertising transparency. This applies to all online platforms. The next speaker will then say more about additional requirements for the very large platforms. But here we're talking about any online platform. If I go on any of these platforms and advertising is pushed to me, I need to get 3 pieces of information if you want. The first one, that I'm seeing an ad in the first place. This already built on the existing requirement, by the way, in the e-commerce directive. So I know I see an ad. The second thing is I need to know who is behind that ad. And thirdly, I would also need information, I would get information, why am I seeing that ad? So was this, for instance, because of my profile that content was pushed to me? This is, by the way, the last remark before I stop, something that is widely debated also already now in the European Parliament. The usual question here would be, why did you not go beyond this? Should we not ban targeted advertising in the first place? I'm not giving you now all the arguments, but just to be clear that this provision as such is not a prohibition of targeted advertising. It is, at this stage, still a pure transparency obligation. And with this, I think I stuck to my 20 minutes, and I gladly hand over to the next speaker.
Thank you very much for this lecture. Before I turn the microphone to the second speaker, I will briefly take a couple of moments to introduce him. Not that the introduction is needed. Next speaker is Professor Gerald Spindler. He's a full tenured professor at the University of Göttingen in Germany, where he's, among other things, mainly occupied with legal issues regarding e-commerce, internet law, and telecommunications law. He was recently appointed by the EU Commission as a high-level expert for legal issues of new technologies, in particular artificial intelligence and liability. Professor, the floor is yours.
Yeah, thanks a lot. I hope everybody can hear me. If not, thumbs down or thumbs up. And thank you a lot for this kind invitation. And could you just make me a co-host so I can present my slides? Okay, hopefully everybody can see that. It is just following up a little bit difficult, the presentation of Werner Stengg, who is, let's say, at the core of all of that. So I just can contribute it, let's say, from the outside perspective a little bit concerning the very large online platforms, which I consider as being the summit of the whole pyramid. As I consider the whole Digital Service Act being a pyramid with basics and just ending up at the top, with the very large online platforms. I can be brief on that phenomena. We all know that we are here in a gray zone between active and passive providers. But what is actually not really addressed in the DSA, they are just sticking to this jurisdiction of the European Court of Justice. But that had been debated yesterday, I suppose. So all these examples are very well known: Uber, Airbnb, Amazon Marketplace, Facebook, YouTube, you name it. What are the problems then? They are more or less being, they can be qualified as gatekeepers for very important phenomena, what is going on in our society, being affecting democracy. You think all of this falsification of fake news campaigns during this US elections, etc., etc. So the addressee of regulation is always a little bit at stake. So can we address ourselves the regulation to the platform provider, or do we have to stick to the one that are behind that? And any other areas are already, I think, being covered: anti-terrorism regulation, anti-money laundering, etc. So what is now about this very large online platform? So first, is it being defined by Article 25? It is more than 45 million users in the EU to manage. And the purpose is that it is about to manage systemic risks. So, but there, sorry that I'm going a little bit into detail. So at first hand, what struck me a little bit was this precise calculation method that should be done in a separate delegated act of the Commission, which is quite well understood. However, you have the monthly active users mentioned in Article 25, but on the other hand, online platforms have only to report it every 6 months about the numbers of users. That is to some sort a little bit of contradiction there, but this is just a minor detail. So what is worthwhile to mention, that we have this market location principle there, that all intermediate services which are provided to recipients of the service, etc., all are these addressed by also the very large online platforms. Though that is to say, even though if Facebook should not be situated in Ireland, or YouTube should not be situated in Ireland, etc., then we still can apply the DSA to them, which is quite something, a progress which is taking up all the approaches which we are all well aware of the GDPR already. So what I said already, the reason for treating very large online platforms a little bit different as online platforms in general, as they are being considered gatekeepers, and they can induce, and this is, let's say, the buzzword for all of that, systemic risks. So what are these systemic risks about, and where do they come from? So I got my impression, but Werner, you can correct me, please, that this is stemming a little bit from the financial market regulation, from the financial market crisis, where we also had been confronted with all these kind of systemic risks. So this just rings a bell in my head. Well, I'm also doing capital markets law, and for that reason, I just draw these parallels concerning systemic risks. So, but what is then all these obligations about? What I'm going to delve more into detail in the following minutes. For me, it was in some more about corporate governance obligations, and that they should be enforced more by means of supervision by a digital service coordinator or by the European digital boards. And I think Hans Schulte-Nölke will also more elaborate on that. But this is in first line public law obligations. So if we can convert it into something like civil law or obligations or unfair competition law, or how it could be reflected in contractual obligations, that is, to my mind, still an open question. So let's go on to a little bit more of the detail. So what are these very large online platforms then are obliged to? So first, they have to conduct risk assessments. Once again, ringing my bell, financial market regulations. This is so a parallel. So what is that then? What is systemic risk then about? It's dissemination of illegal content. And then this general clause, any negative effects for the exercise of the fundamental rights. So that covers more or less everything. So, but how should a platform then really evaluate what systemic risk and negative effects are about? And then third, intentional manipulation of the service. That might be more easily to grasp if somebody is launching, for example, a disinformation campaign or something like that. And what is then the consequence of all this risk assessment? Well, once again, the parallel to financial market regulation, you have to have risk management systems to take reasonable and effective measures aimed at mitigating those risks. So, and a little bit more hints what is meant by this is contained in Article 27. So, for example, adapting content moderation or recommender systems, decision-making process, etc. And once again, the Commission may adopt guidance for how to mitigate risks. So that would be very, very interesting to see what the Commission will adopt there as guidance. I just remind you of the fact what happened to Article 17 of the DSM directive and how difficult all this process had been and how abstract it still is. So, well, let's see. Next obligation also is a reminder of financial market regulation. What are they obliged as well? To submit themselves to external and independent audits. So this is to say they have to engage auditors, which should be independent. But what is independence? So there's nothing really more specific about independence there, Article 28, in contrast to what we have in the real auditing world, which contains, for example, some provisions on rotating or what happens if an auditor is inside a corporate group, and so on and so on. And there's nothing there about liability of auditors if they are just reporting, let's say, in a false way. And Article 28.3, so then the audit report should also contain recommendations, but on the other hand, there's no obligation to implement these recommendations, but they have to explain it then the very large online platform has to explain why they're deviating from these recommendations of the auditors. And the supervision aspect is being stressed on, as if you see in Article 28 as well, that all these reports have to be delivered to the Digital Service Coordinator as well as the Board of Digital Services. But Hans Schulte-Nölke will go more deeper into that, I suppose. So next article, that is more specific on the recommender systems. And this is a more user-friendly here because I strongly support this point. So to enable users to change the parameters of the system, which on the other hand is somehow a little bit contrary to the business model sometimes. So there could be some constitutional argument on this level. But at least they should have the option, at least one option, that is not belonging to profiling. So it is a little bit to enhance and to foster what already the GDPR envisaged in Article 22. So, and Werner already mentioned that for the normal online platforms that they have to display online advertising on their own online interface at least once per year, and also including personalized advertisement and use parameters. And so what is that up to? That is just to enhance public transparency as another tool of, let's say, enhancing and fostering supervision of these very large online platforms. And I am sure that this will also instigate a lot of discussions concerning on the public level, but we're not talking about the Digital Markets Act today. But here in Article 31, the Commission, as well as vetted researchers, they should have access to data, to everything what the very large online platforms are generating. And that goes to the core of their business model for sure. So this would be quite interesting how European Parliament and lobbies, etc., will cope with that. But in fact, it is necessary in order to assess how these very large online platforms really act on. So also corporate governance aspect, and also I suppose a little bit taken from the financial market regulations concerning systemic risk, is the obligation to appoint one or more compliance officers. Hey, this is once again what we know from the capital market regulation area. So what is their task? Well, as the notion already tells you, it is to ensure compliance with the obligation laid down, and they should be also independent. But there are no further safeguards concerning independency. So should they be shielded from being fired for whatever reason or what? So there is some sort of lack, let's say, of substantial information about what is going to be considered as to be independent. So it could be, let's say, a sword without a blade. So if there is not a little bit more concerning independency. So, but what their task is direct reporting to board of directors, which goes without saying for compliance officers. And moreover, and I skipped that, we have specific additional transparency reporting obligations, which are for some sort, it was a little bit my impression that it was a little bit taken from the blueprint of the German Network Enforcement Act. So now coming to the end, codes of conduct, and this is my obligation as well. So a little bit apart, let's say, from the very large online platforms. And here the DSA does not provide for any specific claim for damages and not for contractual implications, which is coming for a little bit of surprise, well, at least for me. But what about now the codes of conduct? Article 35 tells us that the Commission should foster development of code of conduct as well as technical standards. However, in contrast to Article 40 of the GDPR, there's nothing said about legal implications if you follow these codes of conduct or if you don't follow these codes of conduct. Only recital 68 tells us that there is some indication that if you're not participating at this code of conduct, it should be considered as an infringement of obligations under the DSA. In contrary, the participation should be considered as a part of mitigating systemic risk. So, but why is it hidden in the recitals? So this is something I wondered about, because in Article 40 GDPR, it's more clearly stated what the implications of following a code of conduct could be. So crisis protocol, to be very short on that, this is just for crisis that they have very large online platforms. They have to establish an action plan for how to cope with the crisis. They should assign specific tasks to people, everything you can imagine. And this is already also a little bit similar to what you can see in chemical regulation area, for example, where you also have to establish crisis protocols. Okay, enforcement, very large online platform. I just skipped that because I suppose that Hans Schulte-Nölke will give a further talk on that. Just to state here that the Commission has implemented in their proposal of the Digital Service Act an own chapter only dedicated for the supervision of very large online platforms, which shows how much importance they assign, let's say, to the regulation and supervision, mostly belonging to public law enforcement, and which is also a little bit reflection of what already had turned out during the GDPR, that a national enforcement, and to just keep it at the national level, may lead to troubles concerning, let's say, concerning the conformity of public enforcement of national authorities. So my overall assessment of that would be, it is largely following systemic risk approach. As I said already, looks a little bit similar to financial market regulation. But the problem is, how do you assess systemic risk? What are really systemic risks here about? In financial markets, it's much easier to assess that. But here, concerning the whole democratic procedure and freedom of speech and everything of that, how should you really balance that? And that leads me to this triangle, which Werner already also just mentioned, this triangle of this balance between fundamental rights provided, users, and damages in endangered public. This is really sometimes very hard to strike, and surely for a provider who should not be pushed into the position of being a judge. But this is already referring to what has been mentioned yesterday concerning this certified judicial bodies. So it struck me a little bit that it's more or less purely administrative, and you have a lot of punitive fines. They may work. However, we have to keep in mind that this supposes to really have enough manpower which is available for supervising authorities. And the lessons what we learned from the GDPR is that it should be better to flank it with unfair competition law and contractual or tort law obligations than only to rely upon public supervision. Okay, thanks a lot.
Thank you very much, Professor, for your talk. Before we go to the last segment of this session, the comments, I would just like to repeat for our audience that the questions will be pulled and answered together after the comments. And of course, there is an option to ask those questions with audio and video. You just have to click on raise hand button below in the middle of your screen, and then you will be added to the podium when you can ask your questions. So last but not least, the comments that will be provided by Aneta Wiewiórowska-Domagalska. She, to introduce her briefly, is finalizing her habilitation at the European Legal Studies Institute of the Osnabrück University and is member of ELI Council and one of the reporters in the ELI's Model Rules on Online Intermediary Platforms project. She also co-chairs the Consumer Expert Forum established by the Polish Commissioner for Human Rights. Previously, she worked as an expert for the Polish Ministry of Justice, negotiating private law instruments in the EU Council, as well as for the Polish Civil Law Codification Commission, and was involved extensively in the transposition of EU directives into Polish law. Aneta, the floor is yours.
Thank you. Thank you very much. I'm not sure if I'm already on screen. I can see you. Yes, okay. Thank you very much for having me. I'm really enjoying this conference enormously. And I know that I'm supposed to comment on the two previous speeches in my panel, but I would like to begin with a more general observation. I think the greatest strength of this conference is the fact that it clearly shows that there is a need to discuss in a greater depth the assumptions on which the DSA package is based on. And I think that was also reflected in Professor Spindler's speech. Today and yesterday, we've heard public law experts, private law experts, fundamental rights people, free speech people, competition gurus, probably with constitutional background, and the variety of experts that you need to discuss this proposal package properly shows us that this is a very multidimensional act, or will be a multidimensional act. What we are dealing here, in fact, is, I'm not sure if you can call it, but like this, but digital realm constitution for the people of Europe. It touches upon various sorts, freedoms, rights, and duties. The question that comes to my mind is the construction that it assumes, that it takes, is adequate to address the so differentiated issues that it tries to regulate. So in other words, can we define all the problems on the model digital world through the concept of illegal content? Is it enough? Or maybe it is a little bit too reductionist for the digital world. And I'm a private lawyer, so that is my starting point, my position for viewing these provisions. The second observation, which I have, is related to this panel, but also speeches of yesterday, in particular, Professor Rodriguez. And this is whether the concept of dealing with this new digital world through the attempt to intervene in the way the platform organize the marketplaces and activities, it will be sufficient to safeguard the position of EU citizens, consumers, clients, businesses, SMEs, you name the category. When it comes to the fundamental rights, but also economic rights. And coming to this panel, the question that I have, and I might be a bit stronger than Professor Spindler in this regard and much more provocative, is that whether we should base our legislation on hopes, hopes that we have for the future, or whether we should rather build it on our experience. And the experience that I have, and maybe because I'm Polish and dealing with consumer law, is that if something might go wrong, it definitely will go wrong. So the question is whether relying so much on the goodwill of technological giants will grant sufficient security for EU citizens. Or maybe this is a moment when we begin to share the state or European Union begins to share the legislative competences with the private entities, the technological giants or VLOPs, very large online platforms. And I know that this is a provocative thought, and I know that answering it requires taking a thorough look at the presentation of Professor Schulte-Nolke that will follow on the enforcement system and sanctions. But this is something that we should probably keep in mind. And then I would like to just throw a few questions regarding the provisions that have been just discussed. First of all, I would like to ask whether the rules contained in these two chapters or three sections that we are discussing at the moment should be really limited, some of them to very large online platforms and the rest for online platforms, but with the exclusion on small and medium enterprises. Are the risks for individual users lesser on smaller platforms than on large platforms when it comes, for example, to the recommender system? Why recommender system is only for VLOPs? What about the traceability of Article 22, if I remember correctly, traceability of traders? If an online platform gives an opportunity to conclude a contract online, does it matter for the user whether this is a huge platform or small platform? It is equally important to know the contractual partner. Then measures and protection against misuse. This is about repeated events. What about situation when we faced one-time huge event with huge consequences for the ecosystem, digital ecosystem? How do we deal with that? Plus, there is a very interesting formulation in the motives. How do you recognize manifestly illegal content? You should look at it through the eyes of a layman. And my question is, who is layman on internet? Is this the person who believes that Earth is flat? Is this a person who believes that when you take vaccination, you suddenly have a chip in your brain, courtesy of Bill Gates? What's the measure to identify this person? Then Article 21, notification of suspicions of criminal offenses. One size fits all solution. First of all, what about why some platforms will be excluded from this obligation? Second, what about situations when platforms specialize with contracts, and again, I'm a private lawyer, contracts that involve contracts with presence of two parties when the risk of murder rate is higher? How do we deal with this situation? And at the end, I would like to pose questions about the conceptual assumptions concerning VLOPs. So the special obligations for very large online platforms. First of all, it is the VLOP who should evaluate the systematic risk. It is the platform itself. But it is the platform that causes it, and it is the platform who benefits from it. I understand that there are safety measures to make sure that this is happening, but in principle, this is a self-assessment project in which the VLOP should critically evaluate its organizational model. Next, it is the VLOP who should put forward mitigation measures that will potentially have an adverse effect on its profitability. Then we have independent audits, and Professor Spindler has already talked about it. But if this the model that follows model of the financial sector, then, well, we can see that it's not working very well for the financial sector. And this is where I'm engaged in Poland, and the problems are really huge. And then we have compliance officers, independent guardians within the organization, paid by the organization, reporting to the higher management. And Professor Spindler also already told about this, but I can see how utterly independent is a person who needs to report to Mark Zuckerberg. I mean, are we creating a fiction here? So here I would like to stop and give time for discussion. Thank you very much.
Well, thank you very much for your comments. As always, the right to first after comment goes to the both other speakers. If you want to reply directly to the comments, I might hand you the floor. Otherwise, we can go to the questions posed by the audience. I will.
Should I start?
Yes, please.
Yeah, in a chronological order. Yeah, thank you very much both to Mr. Spindler and Aneta. All pertinent questions. Yeah, I mean, believe me, it's not been an easy task to write this piece of law. I don't know. I hear my own echo. I hope I'm being understood more clearly on your end. Okay. I'm just irritating myself here. Because there's so many balances to be struck, so many things to be considered. You know, it's much easier to identify the problems than it is to come with solutions that make sense, that are proportionate, that are effective, that don't stifle in innovation, that make sure that illegal content is removed, but legal content stays online. For years have we been struggling with all these issues, and what you see before you is our own best effort undertaking. The problem is, and both, I think, Mr. Spindler and Aneta, if I say Aneta, it's just because your second name is too complicated for me. We're talking about something very complicated out there, systemic risks already, Mr. Spindler. When we have tried to say what kind of areas we mean by that, and you often refer to financial services legislation, there may be some parallel concepts, but it's still not a one-on-one copy of the concepts. But it just very colloquially, of course, systemic was meant to say big, a lot, you know, and that's one of the proportionality assessments already. If some illegal content is spread on a small platform, I agree with you, Aneta, that for the individual that is also bad. But if that happens, you know, with regard to 100 million people, then the impact that this has is just much, much bigger. So whether this now concerns, I don't know, illegal products coming in from China, if there's hundreds of thousands of parcels coming in through rogue traders that don't comply with our product safety standards, that is just to be dealt with as a matter of priority. And we directed all our efforts on where the problem was biggest. And if Facebook is abused for spreading fake news on COVID, obviously it also reaches so many more people than a small, probably national social media company. So it is this proportionality element. I think we did identify the broad categories of systemic risk, because we said, of course, on the one hand, it's about illegal products or content. The other is about risks to fundamental rights, possible restrictions to the freedom of expression, coming also from their own systems, by the way. So when they use algorithms and artificial intelligence to decide on what type of content is removed or not, then they need also to properly assess the risk of that for fundamental rights, as much as disinformation as the third category, running up to possible manipulations of elections. Now, this already shows this wide range of issues that could be problematic, and we're also talking about very different types of platforms. There are certain limitations in our work by the fact that we're talking about any type of big platform, whether it's an app store, whether it's a social media company, or whether it's a marketplace with sales coming from China. So it would have been hard to be more prescriptive in what all of these platforms would have to do. You, Aneta, you said, well, we leave it up to the platforms. But in the first instance, that is as much as we can do, but we force them to do that. We increase the transparency and the possibility for others to double check that information. This is also where the vetted researchers come in, for instance. And then we have also this enforcement chapter that will only be discussed in the next session, where if we find that large platforms only pay lip service when it comes to their risk mitigation measures, well, then we can actually, we also have strong enforcement mechanisms there. So it is a step change compared to the status quo. Will it eliminate all risks from the internet? No, it won't. There are also other limitations. We are talking about content moderation, which is inherently, there's always this risk that also too much is removed. The more stringent we are, the more demanding we are on measures taken to make sure illegal content is removed at all costs, the more this leads to over-removal. We have seen this many times in the past. Also, some national laws may have been more an invitation to do that. I remember workshops with hosting service providers, medium-sized ones, not the very large ones. They said, you know what, whenever I receive any sort of notice from whoever, I remove that stuff. I don't have an army of lawyers to double check that, but the risk of liability is too high for me, so I remove. So we always have to make sure that we don't incentivize over-removal while at the same time allowing for enough checks and balances out there. I could go on for ages, but I don't want to monopolize this. So over to the next one.
Okay, so Werner, you have touched so many points that is really hard to recommend on you. And first of all, I think we all very much appreciate your efforts that you have undertaken at the Commission. And this is really a huge effort, this Digital Service Act. So don't get our criticism, let's say, on the wrong side. It is just, let's say, the ordinary discourse, what we are going on. And yeah, sorry, well, maybe you remember that I've been 2006, 2007 already. Yeah, okay, but this is former stuff. Concerning, well, so just for a clarification, I don't get the point where you're talking about systemic risks. So, okay, you have not copied it one-to-one, but obviously you are conceiving systemic risk in another way that is usually being perceived. Systemic risk means that if one in the whole domino chain falls, then the other ones are also affected. But you are just referring to the proportionality principle. So it may be just a linguistic issue, but I would not talk about systemic risk here, but it is more reasonable to talk about proportionality at that point. Concerning what Aneta just talked about, all this, a compliance officer, risk assessment, etc. Well, you're absolutely right. It would not hinder any type of criminal behavior of platforms. Now, it would not. So you have always these flaws concerning risk assessment and internal risk management, etc. But the problem is, what is then the first best solution to that? And so I understood that proposal also of the European Commission as to be more or less second best or third best. So because you don't have really very much better alternatives. If you look at a lot of regulations around in Europe as well as on national level, you will see that they are always referring and they try to strengthen the internal corporate governance. So because whatever is the alternative, that is to say that you have millions of people that should supervise these online platforms. And this is just one of my main points of criticism concerning these very large online platforms, because then you can only get out the very hot stuff, the very hot topics of that, because you will never have enough manpower really to have control on them. Now, this is, let's say, my main point of criticism. So may render it more effective civil law sanctions as well as other sanctions, being unfair competition law, for example, because that turned out also under the GDPR to be more effective than just public supervision.
Well, thank you very much. I will pose one of the questions from our chat. Oh, you would like to reply? Sorry, please go ahead.
Very briefly, really, because what I said at the beginning was that, maybe I didn't spell it out properly, is that I have a feeling reading the proposal that economic interests, economic rights of consumers somehow get lost in the fake news and potential threats to democracy. Are we approaching the two in the same way? Should we approach the two in the same way? And then just follow up on what Professor Spindler just said. There is no way to effectively deal with the market power that the platform have through public law measures because of the manpower. So where are we? Are we at this moment in the history of human life when we admit we have lost control over certain sectors of our market?
Thank you for this great discussion. We only have a couple of minutes left, and I will take one question from the FAQ section and say sorry to all of those whose questions will not be answered today. It's a great discussion, but we would need the whole afternoon for it. I will pick out a relatively specific question, which goes to the relationship between the DSA and platform to business regulation when it comes to possible overlap in the complaint handling mechanism. Does this mean that a business can choose whether they go for DSA or platform to business complaint handling procedure, or is this overlap only? It's not something that then holds ground when one goes into detail. And the second question that is framed the same way with regard to overlap is algorithmic transparency in platform to business regulation, where rankings are also discussed and regulated. It's up for grabs. Whomever would prefer to start. Maybe we turn the order around and go to Aneta first, if you would.
Yes, I just would like to say that I would really love to hear the answer to that question. So I'm passing by, because similar questions pop up in my head when it comes to the relation of the proposal and other pieces of EU legislation. So I don't think this is going to be the only one place where this question will arise. So I would love to hear the answer of the drafters. Sorry.
Well, as far as I got it in my mind, but I think Werner knows the DSA Act much better than anybody else. I think it was, let's say, in the beginning of the DSA when this public to business regulation had been left untouched. So that means that the DSA should be cumulatively being applied to that. But if there is a special rule contained in this P2B regulation, then I think the DSA should be overruled. But this is just a preliminary approach.
Which is perfectly correct as far as we are concerned. And by the way, I haven't taken anything anybody has said as criticism or undue criticism. It is very important to have these discussions. Just as a preliminary remark before answering the question, for years had we shied away a bit from opening up the e-commerce directive because it's controversial and you're having all these discussions about content moderation and upload filters and so on and so forth. And we said, we must have this democratic debate about the internet that we want. And that's a bit also Aneta's question from before, whether we have lost control. I think both the DMA and the DSA are trying to regain some democratic control over processes that affect our markets and our societies. And naturally, we're having discussions, and naturally, we will never all agree on what the perfect paragraph or article is. So I didn't take anything as criticism. You were quite right in that the DSA is a horizontally applicable framework, and there are numerous sector-specific frameworks that are more specific and obviously apply in their own fields. The business to platform regulation, however, did serve as a blueprint for both provisions that were referred to in this question. And I know this because I was actually negotiating the platform to business regulation. And there we had developed this complaint handling mechanism for the business user of platforms. So you are being delisted, you are a hotel on booking.com, you are a third-party seller on Amazon, you are an app developer selling on the App Store. And it was to rebalance this contractual relationship between the platform and the business user. It's always based on a contractual relationship. You sign the terms of condition, terms of service of that platform to sell through that platform, and you're being delisted overnight, probably 3 weeks before Christmas. That is why we integrated sort of this, actually the whole, even before that, also the statement of reasons that we have in a DSA, you will also obviously find in the business to platform regulation, because if my business or part of my product is delisted, I need to be informed immediately, and then I have this access to the complaint handling mechanism and to out of court and so on. And here we said in the DSA, let's mainstream that to anybody whose content was removed. So obviously, when you are a business user and this is covered by the platform to business regulation, that is the more specific law that prevails. But in substance, it even looks pretty much the same if you want. But it's certainly more specific law that prevails. The algorithmic transparency, similarly, at that stage, we had looked at it from the sole lens of the business user. Do I have any idea as a hotel why on booking.com I'm on page 35 today and yesterday I was on page 5? What has happened? Already there we had the debate that we're not going to ask for publication of the code and total transparency of the algorithms for various reasons, but we said you need adequate transparency to understand the main parameters affecting ranking in this case. Now we said that is not only interesting for the business user selling through a platform, what do I have to do in order to improve my ranking, or what explains a sudden change in my ranking position, but we said algorithmic transparency concerns all of us, also as citizens. And if I'm seeing information, but I don't see other information, or Gerald sees other information than I see, we should have some decent understanding of why it is that I see what I see. So in both cases, the business to platform regulation was sort of inspiring us, but in both cases, the business to platform regulation covers, of course, its own field, and then all the rest is covered by the DSA.
Well, thank you very much for this great answer. Because we have 5 minutes left, I would like to pick another question from the FAQ, and let's have a quick firing round. Everybody just gives a quick answer to it, and it is about transparency measures that are not a new tool for governing online platforms, but that are in sorts been put forward in the DSA as a tool that will now help us rein in this platform power, right? So the question goes to, what are the big improvements and deficits of the DSA in the area of transparency? And as this is the third round of answers and Gerald has not begun any of the rounds, I would like to give him the word first. Thank you.
Yes. Well, thanks a lot. There's not much to be said about, because I just, I agree with that, strengthening all these transparency publications. We have already seen in the German Network Enforcement Act that it had some impact upon the behavior of platforms. And for sure, concerning online platforms and very large online platforms, this obligation to publish, for example, decisions which had been taken automatically, etc., and being transparent about algorithms, that I think that really would foster, even keeping in mind that there's also this more or less pseudo supervision by non-governmental organizations, which they benefit then very largely by all these transparency reports. So if they're addressed to the public, I completely agree to that. So even though it might be a little bit burdensome for some platforms.
Aneta, would you like to jump in?
Yes, I think like following on what Professor Spindler just said, I think this concept of external entities representing special interest group having access or having impact on how the platforms are working and how the transparency is being established throughout those networks. This is very important. And actually, this might be the element of democratic accountability of platforms, even though it is constructed in a different way. So I think from here, this perspective, this is something very interesting, and maybe just changing the mechanism in which the control over market is being exercised. So, but you know, the question is, will it work or will it not work? That's another issue. Let's hope it will. Thanks.
Werner, 2 minutes for your last statement before we close the session.
First observation is, of course, the DSA is not just about transparency, because there was often a criticism of the business to platform regulation, which also was more than transparency, but mainly transparency. And by the way, in that case, we said there are certain circumstances when transparency is not enough, which is why we came with the DMA, which you discussed yesterday. Now here, we are talking, first of all, a set of obligations that are well beyond transparency. Already the obligation to have notice and action systems in place and to act expeditiously on illegal content is now a positive obligation, which in the e-commerce directive was only sort of a consequence. If you don't do this, you are no longer protected from liability. But now it is an obligation, and you can be punished and sanctioned if you don't have this and don't do this. Same for Know Your Business Customer, to respond to orders from law enforcement, and so on and so forth. Transparency, on the other hand, we also try to make sure that it does not stay an empty shell, but that there is also consequences attached to that. We discussed in Gerald's presentation data access requirements for law enforcement, for vetted researchers. There is more scrutiny also of auditors and so on. And if there is reason to believe that the platform is not living up to its obligations, then there's all the sanction mechanism. So of course, transparency is an important part of that. My only argument is this whole proposal goes way beyond transparency.
Well, thank you very much for this final thoughts of our panel. With this, I would have to close the session. We have another session coming right up afterwards, and thank you very much for your participation in this session, in the conference in general, and in the discussion that we're having. Thank you, and have a great rest of the event. Thank you.
Thank you.
And now, I guess William will take over with chairing the next session. Thank you.